I am Professor Kshitij Bansal. I am a faculty member at the Law School of O.P. Jindal Global University. I am going to discuss module number 22 today with you, which is National Law and Policy on Water. Let us begin with the module overview at the beginning. While water remains one of the most abundant resources on Earth, but less than 1% of the total supply is reliably available for human consumption. In India, water law is made of different components. It includes international treaties, federal and state acts. It also includes a number of less formal arrangements, including water-related policies, as well as customary rules and regulations. In April 2002, a new national water policy was announced in India. Each state in India is obliged to formulate its own water policy within 2 years of the national policy. Non-governmental organizations in India have increasingly become concerned by some of the provisions in this national water policy and the fact that some states appeared to be simply copying this policy without taking into account the uniqueness and the distinct agro-ecological zones of each state. This module shall provide a brief overview of the right to water under national law and the legal framework that recognizes water as a basic human right. The learning objectives of this module would be to learn and understand the legal instruments that recognize the right to water as a basic human right in India. This module shall also cover as to why quick access to clean water facilities is needed. Thirdly, it will also discuss other events dealing with the promotion of water as a human right. India is eminently dependent on water owing to its large agricultural base, the water needs of its billion-plus population and the recent economic growth trends. Irrespective of abundance in material on environment law, legal work on water laws in particular has been nearly negligible. The laws of Manu addressed issues related to the regulation of water, such as water pollution and its impact on health. Water law has been continuously evolving, and it has been witnessed that over the first 4 decades after independence are remarkably different from the ongoing trends. While until the 1970s, water law can be seen as a field growing around issues and principles that were largely well settled, the past couple of decades have witnessed the beginning of a fundamental shake-up of water law. This is taking the form of reforms which are changing existing water law as well as expanding the scope of regulation. Water law reforms take place due to both physical as well as institutional reasons. Numerous water situations are arising due to rapid increase in the use of water by all categories of water consumers. The increased demand due to economic and population growth, in addition to this, is also because of the growth of population of existing limited water resources, thereby not only restricting potential usages of available water, threatening future use. For instance, the dramatic increase in groundwater usage is the direct cause of depletion in numerous areas. Also, as a part of the economic and financial reforms that were initiated in 1991, the government has made significant changes in the water sector. Despite this, there have been progressive calls for the advancement of the law and policy framework related to water, which can broadly be contributed to 2 factors. First, the water law and policy framework for a very long time has received negligible amount of attention. Secondly, the water crisis in most countries of the world and that availability and access to fresh water will be a challenge for nearly all countries has been a very profound realization. In other words, domestic and international factors have contributed to the ongoing water law and policy reforms. They seek to comprehensively reform governance in the water sector. Right to water needs to be differentiated from the concept of water rights. The right to water is related to the fundamental water requirement for life, water for waste purposes, drinking purposes, washing, and various other needs of personal hygiene, and numerous essential water needs for livelihood. Whereas water rights is the concept that is broadly used in the context of economic uses of water, that is for irrigation, industrial, or numerous commercial purposes. The right to water, as per the definition, is a fundamental right by judicial interpretation. It is a responsibility of the state to ensure such a basic right is not denied to any citizen. The right to water must include the rights of access of certain tribal and other communities to forests, mountains, rivers, etc. That is the natural resource base on which they have for centuries depended for sustenance. Between a fundamental right and a non-fundamental use right, the former is a priority over the latter, since it is the exercise of economic rights should not be allowed to jeopardize the fundamental rights. It must also be kept in mind that water supply and sanitation are interconnected. If there is a right to water, there must also be a right to decent sanitation. Fundamental right to water has been the gift of judiciary in India. The Supreme Court of India has pronounced 3 landmark judgments recognizing fundamental right to water under the Constitution. The first one was Subhash Kumar versus the state of Bihar. In this case, a PIL was filed for preventing the pollution of Bokaro River from the slurry discharged from the washeries of Tata Iron and Steel Company Limited. The Supreme Court ruled that the right to live is a fundamental right under Article 21 of the Constitution, and it includes the right to pollution-free water. A citizen has the right to have recourse to Article 32 of the Constitution for removing the pollution of water or air which may be detrimental to the quality of life. The next major judgment was pronounced by the Madhya Pradesh High Court in the case of Hamid Khan versus State of MP. The PIL was filed because of gross negligence on the part of state government for not taking measures before supplying drinking water. The court stated that it is incumbent on the state to improve the health of the public by providing unpolluted drinking water. The state in the present case had also failed to discharge its primary responsibility. The court here interpreted this right under 47 article of the Constitution. Article 47 states that the state has a duty to raise the level of nutrition and standard of living and to improve public health. The third judgment was pronounced by the High Court of Kerala in the case of Vishal Kochi Kudvela Semakarshana Samiti versus State of Kerala. The court ruled that water is one of the primary needs of man, second only to air. Water is in fact the elixir of life. Failure on the part of the state to provide pure drinking water to its citizens in adequate quantities is a violation of their fundamental right under Article 21. The above mentioned judgments essentially recognize water as a human right under Article 21 of the Constitution. There have also been other significant judgments discussing some principles and concepts of water law. For example, the principle of public trust was discussed in the case of MC Mehta versus Kamal Nath. This gives the government a fiduciary duty to ensure that water is preserved and judiciously used. The court further ruled that the state, as a trustee, is under a legal duty to protect the natural resources. In the absence of any legislation, the executive acting under the doctrine of public trust cannot abdicate the natural resources and convert them into private ownership. This principle was also reiterated by the Supreme Court in the state of West Bengal versus Kesoram Industries in 2004. The court here held that the doctrine of public trust extends even to deep underground water. The court, in another historic judgment of Vellore Citizens Welfare Forum versus Union of India, recognized the precautionary principle and the polluter pays principle. These principles state that the person causing the damage to the environment has an absolute liability for the harm caused. The person bearing the liability would therefore need to compensate the victims and also pay for reversing the damaged ecology. A clear demarcation is made by the Constitution of India that lays down the legislative and functional jurisdiction of the union, state and local governments regarding the subject matter of water. Under the scheme of the Constitution, water is a state subject under Schedule 7 of the Indian Constitution, and the role of union comes up only in case of interstate river water disputes. Water, that is, water supplies, irrigation and canals, drainage and embankments, water storage and power, subject to the provisions of entry 56 of List 1, which is the Union List. It reads as follows: regulation and development of interstate rivers and river valleys to the extent of which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. Article 262 of the Constitution specifically deals with the adjudication of disputes regarding the matters of interstate rivers or river valleys. It reads as follows: Parliament may by law provide for the adjudication on any dispute or complaint with respect to the use, distribution or control of the waters of or in any interstate river or river valley. Notwithstanding anything in this Constitution, Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint as is referred to in Clause 1. The 73rd and 74th Amendments of the Indian Constitution also ushered in a significant change by bringing in a democratic decentralization. Through these constitutional amendment acts, the ultimate responsibility of water supply has been devolved to the elected local bodies in keeping with the trend of decentralization and recent water sector reforms. Therefore, the states would merely lay down the framework of the laws and the implementation would then be done by the municipalities. It is in the 8th schedule dealing with panchayats These subjects, minor irrigation, water management and watershed development, drinking water, maintenance of community assets are listed. In the 12th schedule, subjects dealing with municipalities, water supply of domestic, industrial and commercial purposes have been listed. Functional responsibilities are for local governments in respect of numerous aspects of water use. The Union has also enacted laws on environment and control of pollution which have effect on water use, including groundwater and its exploitation. A large number of acts dealing with irrigation canals and their maintenance, water rates and maintenance of tanks are in force in each state. Coming to drinking water, the supply of drinking water has been one of the major concerns of the state and the central government for the past several decades. Some state governments have enacted specific legislations dealing with drinking water supply. To ensure better supply of drinking water to its citizens, the Union government has been coming up with policies focusing on the supply of drinking water, especially in the rural areas. Essentially, provision of safe drinking water in the rural areas has been the responsibility of the states. The Accelerated Rural Water Supply Program, introduced in 1972-73 by the government to assist the states and union territories to accelerate the pace of coverage of drinking water supply, was an important step. The entire program was given a mission approach and the ambitious project was named National Drinking Water Mission in 1986. This National Drinking Water Mission was renamed as Rajiv Gandhi National Drinking Water Mission, which principally works on the premise of community-based demand-driven approach instead of the traditional forced supply-driven approach. The National Rural Drinking Water Program 2009-2010 also aims to provide every rural person with adequate water for drinking, cooking and other domestic basic needs on a sustainable basis. The policy recognizes water as a public good and also acknowledges that drinking water supply cannot be left to the market forces alone. The emphasis is more on the public partnership approach between the Gram Panchayat and the Public Health Engineering Department, for example, rather than the privatization of drinking water supply. The policy seeks to achieve drinking water security in rural areas by promoting the use of groundwater, the surface water and also rainwater harvesting. Functions of Ministry of Water Resources would be very relevant to be talked about here. The Ministry of Water Resources is responsible for establishing policy guidelines and programs for the development and regulation of water resources. Comprehensive planning, policy making, coordination and proper guidance in the water resource sector is an important function. Secondly would be technical instructions, analysis and monitoring of the irrigation, flood control and multi-purpose projects. Another function is the general infrastructural, technical and research support for overall development. Provision of central financial assistance for certain important projects and aiding in obtaining external finances from the World Bank and other agencies is also the responsibility of the ministry. Planning and policy formulation with respect to minor irrigation, minor participatory irrigation and monitoring of centrally sponsored schemes is also done by them. Broadly planning the development of groundwater resources and formulation of policies to cure exploitation of resources and support to state-level activities in groundwater development is another. Mediation regarding the resolution of disputes in nexus with the interstate rivers and also overseeing the implementation of interstate projects is an important function. Operation of the central network and for flood forecasting, the warning on interstate rivers, the provision of central assistance for some state schemes in special cases. Crucial water-related issues in India are as follows. Dearth of awareness. Inadequacy of awareness regarding the law and policy framework is still a crucial issue in India, especially in the rural areas. There is a major lack of awareness about the scope and implications of such water-related policies and laws. In India, both human right to water and right to sanitation continue to remain an alien concept. Therefore, there is an extreme need for intense and continuous distribution of information about reforms in the water sector and law reforms with special attention to rural areas. Lack of participation is the second. The absence of public participation in law and policy making methodology is an ancillary effect of lack of general awareness. Essentially, law and policy making process is a proper approach wherein people are at the receiving end as mere audience and end up having no role in the framing process of such rules and policies. Present day scenario is worse off in the rural areas where majority of population is unable to read and write, which ultimately results in the poor public consultation in the law and policy making process in the rural areas. The notion of participation is also significant from the implementation perspective of several policies. Hence, an immense focus has to be exerted to make public participation work effectively. Third issue is the gender and caste discrimination. Gender and caste are two significant factors that require a fair amount of attention in the law and policy framework related to water and sanitation. Women and people belonging to lower castes dominate the neglected sections. While there is an abundance of surveys and studies contending that women can play a crucial and effective role in water resource management and development, they continue to remain out of the picture of framing and implementation of various policies and schemes related to water. Caste is another factor unique to India, as always is, that determines the access to drinking water. Due to caste discrimination, lower caste people usually end up waiting as long as higher caste people fetch water enough for themselves. Hence, more affirmative actions are needed from the side of the government to eliminate these antique human practices. Civil society organizations can also contribute significantly by disseminating the idea of human right to water so that access to water shall not be denied to anyone on the basis of caste, gender, and economic capacity. Concluding, water law in India comprises of a number of formal and informal laws, rules and principles. It has gradually evolved over time in a relatively uncoordinated and ad hoc manner. This started to change with the progressive realization that existing laws were inappropriate to ensure access to water to all for domestic purposes and inappropriate because of the fast increasing use of a finite resource. Thus, it can be deduced that a clear-cut right to water needs to find a straightforward entry into the Constitution of India. The minimum core obligation of the state flowing from the right to water of every person has not yet been defined and specified in India either by the legislature or by the courts. It is also crucially required to confirm the fundamental right to water with the mandate for water supply and management with the rural and urban local bodies. Amongst other things, this should make obvious the fact that municipal corporations, councils, are duty bearers who are obliged to honor the fundamental right to water of every person. Also, in this context of the fact that all the recent decentralizing government initiatives have sought to vest powers, informal village groups and associations. At the heart of all water-related conflicts lies a competitive, unsustainable demand for water. That demand, leaving aside the basic water requirements of a human being, is for water for various uses: agricultural, commercial, industrial, etc. And these in turn arise from the pursuit of development. Restraining the growth of demand for water would therefore require changes in our ideas of development and good of life. The water crisis is part of a civilizational crisis. Thank you.